It was reported that on the 29th day of July, 2011, one Mrs. Sarah was in her house with her two sons when some indigenes of Ayo community in their numbers invaded her house. Among the invaders were Itam, Okon, Godwin and Bassi. The invaders came with weapons and demanded that she bring out her two sons or they will kill her. She asked what the problem was and they informed her that they are on a retaliation attack for the role she and her late husband played in the inter-communal crisis between her village and their village. They alleged that it was her late husband, Barrister Iko, that wrote a petition and reported their community to the police. It was reported that Itam, Okon, Godwin and Bassi among others destroyed Mrs. Sarah's properties with her tenants and ended up setting the house on fire. In the midst of the mayhem, one of Mrs. Sarah's sons who tried to escape through the bush was caught by Itam, who cut his body with a machete while another attacker, still at large, fired the boy on the head. When Mrs. Sarah saw what happened and rushed to help her son, Itam and others hit her with a rod and rode off on a motorcycle with her son, and since then, she has not set her eyes on her son. Following the incident, she quickly called the DPO of the division, who arrived at the scene with some policemen and army men, who then arrested Godwin, Okon, Itam and Bassi while the others escaped. The four of them were charged before the High Court of Akwa Ibom State, Oron Division, for the offenses of arson and kidnapping, contrary to Section 464 Paragraph A and Section 46 Paragraph A and B of the Criminal Code of Akwa Ibom State, and Section 1 of the Internal Security and Enforcement Law of Akwa Ibom State, 2009. At the conclusion of trial, the learned trial judge discharged the fourth accused person on the ground that he had serious doubt if he was present at the scene of crime. However, the learned trial judge convicted Itam and the other two accused persons, Okon and Godwin, and sentenced them to death by hanging. Unhappy with the decision of the court, Itam filed this appeal before the Court of Appeal Calabar Division. At the appeal, Itam's lawyer formulated 4 issues for determination. On issue 1, he argued that the learned trial judge was wrong to have convicted Itam on the same set of evidence by the same witnesses that he relied on to discharge the fourth accused person. He contended that the evidence of the prosecution witnesses, who were Mrs. Sarah and the police IPO used by the trial court to discharge the fourth accused person, are interwoven with the evidence adduced against Itam. He argued that since Itam and the fourth accused person were charged with the same offenses, if the trial court found any reason to discharge the fourth accused, he ought to also, based on the same reason, discharge and acquit Itam too. In response to this issue, the prosecution, who was the respondent at the appeal, argued that Mrs. Sarah, who testified as PW1, successfully distinguished the role each of the accused person played on the day of the incident, including Itam's attack on her son and his subsequent abduction, which evidence was not contradicted under cross-examination. He further argued that where the evidence, as in the instant case, separates the role of each of the accused persons at the scene of crime, it cannot be said that the evidence is inextricably interwoven. He noted that the evidence of Mrs. Sarah, who testified as PW1, and the police IPO, who testified as PW2, separated the role each of the accused person played while carrying out their common intentions. To resolve this issue, the court held that it is a settled principle of law that where 2 or more persons are charged with the same offense and the evidence adduced against them are interwoven, the discharge of one of the accused persons must, as a matter of law, affect the discharge of others. The court further held that for the evidence to exculpate the appellant, such evidence must be joined together like Siamese twins, so much so that all accused persons must either fall or stand together. The court also observed that it is not the law that once an accused person is discharged and acquitted, the co-accused must, as a matter of course or routine, be discharged and acquitted like the night following the day, but each case will be determined by the facts made available to the court. The court found where the trial court held that there is no dispute that the accused persons were fixed at the scene of the crime by the evidence of Mrs. Sarah, and also held that he feels safe to convict on that finding, but later somersaulted to discharge the fourth accused person, on the ground that he doubts if he was at the scene of the crime. The Court of Appeal then concluded that the evidence of PW1 and PW2 used by the trial court to discharge the fourth accused person was indeed one and the same and interwoven with the evidence adduced against Itom and other accused persons, but this court cannot use same to discharge the appellant Mr. Itom, because the findings of the trial judge, who believed the evidence of the prosecution witnesses in one breath and discharged the fourth accused person in another breath, was not supported by evidence placed before it. The court referred to the unchallenged evidence of PW1, Mrs. Sarah, who testified that the fourth accused person, who indeed is her son, was part of the hoodlum who invaded her house, burnt it down, and was among those that kidnapped her son. The court then held that the land trial judge, with respect, was wrong when he turned around to say that he is in doubt if the fourth accused person was at the scene of the crime, as no doubt was created by the evidence on record. The court resolved this issue in favor of the respondent and held that where the trial judge erred in his finding of exculpatory evidence to discharge the fourth accused, this court cannot base on such wrong finding to discharge and acquit the appellant, Mr. Itom. The court noted that although the evidence used by the learned trial judge to discharge the fourth accused person is interwoven with the one adduced against Mr. Itom, but it will work injustice on the society for the Court of Appeal to hold that the trial court should have also based on its wrong finding to discharge and acquit the appellant, Mr. Itom. Thus, this issue was resolved in favor of the respondent. On issue 2, Mr. Itom's lawyer argued that there was nothing confessional about the statement Itom made to the police that was tendered in the trial court as Exhibit K. He contended that there is nothing in that statement that stated or suggested that it was the appellant, Mr. Itom, that committed the offense of arson and kidnapping. He further argued that the failure of the trial court to evaluate the extrajudicial statement with his oral testimony rendered the findings of the court perverse. In response, the respondent counsel pointed the court to some part of the Exhibit K and submitted that the mere inference that Mr. Itom was part of the mob that invaded the house of Mrs. Sarah with the common intention of committing arson and kidnapping is enough to make his statement confessional to the charge proffered against him. He also pointed that the failure of Mr. Itom to object to the tendering of the said Exhibit K deems it to have been voluntarily made and that the said exhibit was corroborated by the evidence of PW1 and PW2. In resolving issue 2, the court reproduced the provision of Section 28 of the Evidence Act, which states that an admission made at any time by a person charged with a crime stating or suggesting the inference that he committed the crime amounts to a confession. The court held that confessional statement is the best form of evidence to use and convict an accused person, especially where it is made voluntarily. The court also held that confessional statement does not become inadmissible simply because the accused denied making it. The court noted that Itom's statement to the police was tendered at the trial court without any objection and it was admitted as Exhibit K. The court found that in the said statement, Itom noted that he was among the mob that invaded Mrs. Sarah's compound and set her house on fire. The court held that Exhibit K is enough inference that Mr. Itom confessed to the crime. The court thus resolved issue 2 in favor of the respondent and held that the land trial judge was right when he held Exhibit K was a confessional statement. On issues 3 and 4, the land counsel for the appellant argued that the trial court failed to place the evidence of the prosecution witnesses side by side with the evidence adduced by the appellant, Mr. Itom, before arriving at the conviction of the appellant. He argued that the evidence of PW1 and PW2 were marred by contradictions on material facts, thereby rendering same unreliable. He also contended that the learned counsel for the respondent failed to discharge the evidential burden of proving the offense of arson and kidnapping beyond reasonable doubt as required by law. He therefore urged the court to allow the appeal and discharge and acquit the appellant, Mr. Itom. In response, the respondent submitted that the evidence of one credible witness, if accepted and believed by a trial court, is sufficient to secure a conviction in a criminal trial. He urged the court to hold that the evidence of the victim, Mrs. Sarah, is the best evidence which needs no corroboration. On the issue of contradiction, Land Counsel argued that the contradictions are minor and do not go to the root of the case. In resolving issue 3 and 4, the Court of Appeal held that the credibility of an evidence the prosecution required to secure conviction does not depend on the number of witnesses he called. In other words, the evidence of one credible witness when believed by the trial court can ground conviction. The court further held that the evaluation of evidence and ascription of relevant probative value thereto is the primary duty of the trial court, which had the opportunity to see and hear the parties and assess the witnesses, and that the Court of Appeal is caged to intervene with or reverse findings of fact made by the court of trial unless such findings are perverse. The court found from the record that the learned trial judge assessed the witnesses and upon consideration of the demeanor of the witnesses, believed the evidence of the prosecution witnesses, particularly the PW1, Mrs. Sarah, against the evidence of Mr. Eaton. The learned trial judge disregarded his evidence because it did not create any doubt in the mind of the court, more especially is that his oral evidence was at variance with his extrajudicial statement, Exhibit K. The court held that it is trite that where an accused person is shown to have made a statement previously, which is inconsistent with the defense given at the trial, a trial court would be right to conclude that the evidence given at the trial is unreliable, aimed at exculpating the accused from blame. The court therefore held that the trial court was right in its evaluation of evidence. On the issue of contradictions, the court found in the records where Mrs. Sarah informed the court that the hoodlums invaded her house by 6 p.m. while the police IPO who testified as PW2 informed the court that the invasion was by 7:30 p.m. Secondly, Mrs. Sarah stated before the court that the police and soldiers called men of fire service, but PW2 did not state so in his evidence. Thirdly, the PW2 informed the court that as a result of the threat Mrs. Sarah feared, she slept in their station for 3 months. But Mrs. Sarah did not mention that she was in police custody, not even for a moment. The court in a whole found that the contradictions did not affect the substance of the case and therefore resolved issues 3 and 4 in favor of the respondent. In the end, the appeal failed for lack of merit. The Court of Appeal therefore affirmed the decision of the trial court, which sentenced Mr. Eaton to death by hanging.